This is number 5 in a 5-video series we've been doing with King County District Court. And our returning guest expert is the Honorable Kristen Shotwell. Welcome back, Judge Shotwell.
Well, thank you so much.
Today, we're talking about that tricky thing about small claims judgments.
Yes.
And so first and foremost, what is a small claims judgment?
Well, a judgment is a court order that the winning party of a small claims case receives. So after the trial, the judge, if there's money to be paid, issues a judgment. And it just says that somebody owes somebody money.
Okay. And if I win, I'm the plaintiff and I win, will I get the money right at the end of the trial?
That is a very good question and a common misconception. No, you will not. You will get a judgment. A judgment is a court order, as I mentioned, saying that somebody owes somebody money. The judge does not have the power to tell the defendant to take out their checkbook and pay right then and there at the end of the trial. After the time for an appeal has passed, 30 days, the plaintiff can go about collecting upon the judgment if it has not been paid.
So it's the duty of the plaintiff to follow up on that. Okay.
That's right.
So how long do small claims judgments last?
Judgments last 10 years. They can be extended one time for an additional 10 years if they are not paid in that first 10 years.
Okay. And does interest accrue on the judgment over time?
Sure. Interest does accrue on the judgment. And what that means is that a money judgment is going to get larger every day that it's not paid, because the law requires unpaid judgments to start accruing interest from the day of the judgment. The percent of interest depends on the type of case, but accruing interest is required by law.
Okay. So let's say I have one in small claims court and I did get my money judgment. How do I go about collecting it myself?
Okay, so once you've won your case and you have your money judgment, you can try to collect upon it if the defendant doesn't pay. It can be very difficult, and the best course of action is to consult an attorney who does collections work, or even a collection agency. It's a very complicated area of law, and pro se defendants, people without lawyers, typically don't get it right the first multiple times. So it's probably best to talk to an attorney or a collection agency.
Okay.
One common way to collect on judgments is to garnish the wages of the person who owes the money. But like I said, that is a very tricky area of law, and people would be advised to talk to an attorney.
Okay. And can I sell or transfer my judgment if I don't want to do the collecting myself?
You can, and that's a really common practice. A judgment is a thing of value, right? It has value. It's a court order saying somebody owes you money. So people often will sell or assign their rights to collect upon that judgment to a collection agency. The collection agency, if you sell it, they'll often just give you a percentage of the face value of the judgment, and then they can keep whatever they collect. Sometimes that's how that works. Sometimes if you assign your rights to a judgment, a collection agency will go about trying to collect upon that, and they will give you a percentage of whatever they end up collecting.
Okay, excellent. Thank you again, Judge Shotwell, for all the wonderful information about small claims court. This is going to help people out there. It would be a little more successful in front of you and the other judges.
Well, I really hope so. It's a tricky thing for people to navigate, and thanks for having me.